I'm Andy Arnold, and I practice law in Greenville, South Carolina, and I handle nursing home abuse and neglect cases. One topic that people probably should have some awareness of is the topic of mandatory arbitration. Arbitration is a process by which you essentially privatize the legal system. So instead of, if you have a dispute, if someone's been injured in a nursing home and they've signed an arbitration agreement, then that person may be prevented from going to court, may be prevented from having a trial by jury, and instead has to present their dispute to a hired arbitrator, who usually is a lawyer, to hear their dispute. And they're not entitled to the same discovery. They can't get all the same information in the arbitration proceeding much of the time as they can get in court. There's also an expense to arbitration. There's a filing fee. If you go to court, it's $150. A lot of times arbitration can cost $10,000, $20,000, $30,000 or more. And so there's an expense which creates a barrier to justice. One of the great things about our country is we have a constitutional right to a trial by jury. Arbitration agreements undermine that. Real quick, a couple things you might want to consider. First of all, if you're admitting your loved one to a nursing home, a lot of the times you need to be aware of the documentation you're signing. They're putting a lot of documents in front of you and you're just signing documents and not really knowing what you're signing. Probably one of those is arbitration agreement. You need to understand. The other thing you might want to do in advance is if you have a power of attorney that's drafted, make sure the power of attorney doesn't give you the right to waive your loved one's right to a trial by jury. So even if you sign an arbitration agreement, that might not be enforceable. And if the worst case scenario presents yourself, then the doors of the courthouse will still be open to your loved one.